Hello, my name is Dr. Mark Looney. Dr. Looney is my real name. If you're born with a surname like mine, you've got to get a PhD, really. It's kind of rude not to. So my PhD is in acoustics. This gives me insight into signal processing and that kind of thing, which allowed me to come and work here at the IPO as a patent examiner in telecoms. Telecoms patents have been in the news a lot recently. In 2012, Apple were awarded $1 billion in damages from Samsung. That case will be appealed over the next few years, but it does show how financially important these kinds of decisions can be. So I'm going to talk about patents. A patent is a 20-year monopoly granted in return for full and open disclosure of your invention. The word patent comes from the Latin for openness. In order to reward innovation, reward research, and because the world would be a very different place if the only way you could make money from your idea was to keep it secret. So it's long been recognized that the state does need to kind of step in here and interfere and provide some kind of reward for that innovation. In order to get a patent, your invention needs to fulfill 3 criteria. Firstly, does it have an industrial application? Is it something you can actually make or a process you can actually carry out that provides some kind of technical contribution? A stroke that gets rid of all kinds of creative and artistic ideas. They're more the purview of copyright. It excludes things called business methods. If the only thing that your idea contributes is a business advantage rather than a technical advantage, that's unlikely to be patentable. And it need not just be a financial transaction. In the past, I've objected to a method of giving you your television program when you've watched enough adverts. So it's kind of you buy in the program with your time and attention. Elsewhere in the office, we've had a case where the idea was a prisoner could get a shorter sentence by submitting to corporal punishments, kind of buying time with pain. So these were all considered business methods. There's various other exclusions as well. And this also gives us patent examiners a little bit of a shortcut. We often get applications for things called perpetual motion machines, okay, where you get more energy out than you could possibly get via the laws of thermodynamics. This allowed us to say, your invention hasn't got an industrial application. Come back when you've got your Nobel Prize. So the second criterion is novelty. Is it new? Has it ever been done before? Not just has it been patented before, but has it ever been done in public? If it has, if it forms what we call the state of the art, the prior art, we say that your invention is anticipated and you can't have that monopoly. So when we get a case, we'll try and find the closest example of your invention in the prior art. And we can look everywhere, really. And one of the most fruitful sources of these kinds of citations is, of course, the applicant's own publications. The first rule of patents is like the first rule of Fight Club. You do not talk about your invention, at least not with someone who hasn't specifically promised to keep it secret until you actually apply to us. Now, this doesn't mean that we're kind of East German Stasi officials bugging tables in restaurants and these kinds of things. If you tell your friend in the pub, they will almost certainly behave as if they're under some kind of confidentiality agreement. But just be aware that it is possible that at a later date, they could tell us that you divulged your information in a public place, which might stop you getting your monopoly. The third criterion, not only does what you've done have to be new, never been done before, it also can't be obvious based on what has been done before. It needs what's called an inventive step. As patent examiners, what we do is we become a kind of imaginary person, okay? An imaginary person with no imagination, no inventive capability at all. One judge called him a nerd or a team of nerds, and surprisingly, civil servants don't have that much trouble becoming this person in the course of their day. So we will ask ourselves, we'll look at your invention, we'll compare it to the closest thing we've found from the prior art, and we'll ask, would this invention be obvious to this expert who knows an awful lot about this technical subject matter, but is unable to make any actual inventive step himself? That's the kind of test for inventive step. So there's your 3 criteria, and there's the general ethos of the patent system. Thanks very much.